Well, good evening, friends, and welcome back to our knowledge session, knowledge web session series 5. This time we have tried to curate a discussion around the real estate sector, IBC, and the Affordable Rental Housing Complex Scheme. In fact, there is a very unique symphony between the Affordable Rental Housing Scheme going forward and the kind of objectives it seeks to achieve. The very deep role that real estate sector is expected to play in achieving the housing needs, especially for the lower income groups and the migrant groups across India, as a unique relief measure and social initiative of the Government of India. And of course, in between this entire issues presently created by COVID-19, the insolvency code stands in a very unique footing. The NCLT has a very deep role to play as an enabler to create scenarios of a very balanced outlook, looking at the needs of sustainability, looking at the needs of the stakeholders, particularly the flat buyers or the financial creditors, the other creditors who are associated with the real estate sector, and of course the real estate sectors themselves. This perfect harmony can be created only with a very understanding approach by the National Company Law Tribunals under the Insolvency Code. So allow me to introduce you the very distinguished panel today. We have with us Justice S.J. Mukhopadhaya, the former chairman of the National Company Law Appellate Tribunal, and also a former judge, Supreme Court of India. Welcome, sir, to the discussion today. We have with us Mr. Amrit Abhijat, IAS, Secretary and Mission Director, Housing for All, with the Ministry of Housing and Urban Affairs, Government of India. Welcome, sir. Thank you so much for joining us for the discussion today. Take out time from your very busy schedule, as I understand the kind of wide responsibilities that you have. We also have with us Ms. Parveen Mahtani. Parveen is the Chief Legal Officer of Mahindra Lifespace and a very sharp mind, legal mind, very acknowledged legal mind in the real estate space. We have with us Mr. Gopal Menghani, President, Legal, the Lodha Group. Gopalji has more than 2.5 decades of exposure amongst leading the legal team at large corporate houses. Not taking too many names, but trust me, they're top of the line across the Indian business landscape. And of course, Lodha Group is one of the very dominant real estate contributors to real estate sector in India. We also have with us Ms. Anjana Bali. She's head of legal at DLF Home Developers. And the kind of vision that our Prime Minister has on piloting the affordable rental housing scheme, some of these biggest real estate players are expected to have very deep contribute to nation building. And therefore, the legal minds that we've tried to put together to try and examine the different aspects and the symphony between the affordable rental housing complexes scheme, the insolvency code, and where does the real estate sector stand. We have with us our senior partner, Ms. Shweta Bharti, who will be co-hosting this discussion today along with me. With this introduction of the panel, allow me to welcome Shweta to give an outline on the issues relating to or issues surrounding the approach of the insolvency code and the National Company Law Tribunal that is expected, particularly in the light of a very unique judgment of the NCLAT, in fact, passed by Honorable Justice Mukhopadhaya, which has very deep and lasting effect. I'll request you to give a very brief outline and then request Justice Mukhopadhaya to speak further. Over to you, Shweta.
Sure. Thank you so much. And a warm welcome extended to Honorable Justice Mukhopadhaya, Mr. Amrit Abhijat, Ms. Anjana Bali, Ms. Parveen Mahtani, and Mr. Gopal Menghani. And thank you, Dr. Manoj Kumar. I think this is a unique opportunity for me to be able to speak on this and just give a brief outline of what exactly are we going to discuss today. So housing for all has been a motto of the government, and various initiatives in this regard is presently ongoing to ensure that each family has a house to live in. Now, it is estimated that by 2040, the real estate market will grow to almost about 65,000 crores from 12,000 crores in 2019. So the real estate sector in India is expected to reach a market size of US dollar 1 trillion by 2030, and from US dollar 120 billion in 2017, and contribute about 13% to the country's GDP by 2025. So if you look at the data that has been released by the Department for Promotion of Industry and Internal Trade Policy, the construction is the fourth largest sector in terms of FDI inflow. And FDI in this sector includes the construction development and the construction activities that stood at US dollars 42.50 billion from April 2000 to March 2020. And if we look at some of the major investments and developments in this sector, which has been announced and which is likely to come, in March 2020, the government approved proposals from TCS and DLF to set up a SEZ for IT sector in Haryana and Uttar Pradesh. Blackstone has also, in fact, crossed US dollar 12 billion investment milestones in India. Puravankara is planning to invest almost about 850 crores over the next 4 years to develop 3 ultra-luxury building residential projects in Bangalore, Chennai, and Mumbai. And so on and so forth. There are various other projects which are also in pipeline. So with such fast-paced growth estimated, the real estate sector, which prior to 2016 was largely unregulated, now has 2 key laws hugely impacting it in the recent times. One is the Real Estate Regulation and Development Act 2016, RERA, and another law which had a huge impact on almost all the industries and also had a huge impact on the real estate industry was Insolvency and Bankruptcy Code, IBC. So these 2 laws changed the way in which the real estate sector conducted its business and had huge ramification on the real estate industry in general. So many small fly-by-night operators had to shut their shops, and the serious ones also began to streamline their compliances in adherence with the new laws. So since the focus of today's topic is real estate sector IBC and the Affordable Rental Housing Complex Scheme, I'm not delving too much into the RERA and its implications for today's discussion, and I'm focusing on IBC and real estate. That is going to be the large focus for me in the discussion today. So in November 2017, the Insolvency Law Committee was set up to review the code and identify the issues in its implementation and suggest the changes. So the committee submitted its report sometime in March of 2018, and it made several recommendations. But the relevant one for our discussion purposes was treating the allottees under a real estate project as financial creditors. Subsequently, the amendment came in 2018, which was around June of 2018, and it incorporated these recommendations. So the amendment provided that an allottee under a real estate project or a buyer of an under construction residential or commercial property will be considered as a financial creditor. So these allottees will be represented on the committee of creditors by an authorized representative who will vote on their behalf. So the reasoning that was given by the Insolvency Law Committee was that the amount paid by the allottees under a real estate project is a means of raising finance for the project and hence would classify as a financial debt. So it had also noted that in certain assets, allottees provide more money towards a real estate project than banks. And the amount that is raised from allottees during the sale of a real estate project would have the commercial effect of a borrowing. And therefore, they considered it as a financial debt for the real estate company or the debtor. So post the amendment, plethora of petitions were filed by the individual home buyers for initiation of CIRP against the real estate companies. The threat was so severe that many real estate companies began to settle the matters, and the moment a buyer would approach the NCLT, there were other set of developers, though they are less in numbers, who were happy that they no longer have the burden of completion of the project, and their worries were now taken over by the IRP for arranging of funds right to the completion of the project. So there was a clear divide between the home buyers and the allottees as well, who were keen on one set who was keen on getting the project completed vis-a-vis allottees who were keen on getting the refund back of their money with some interest. So in 2019, August of 2019, there was a landmark judgment of Honorable Supreme Court in Pioneer Urban versus Union of India case, which took into consideration all the issues that were raised by the developers, as well as the home buyers, and considered various factors, and finally held that allottees, home buyers were to be included in the main provision, that is Section 58F, with effect from the inception of the court, and the explanation being added in 2018 merely to clarify the doubts that had arisen. So this judgment paved the way for initiation of CIRP of many real estate companies, one of which was Umang Realtek, which was an Opal's joint venture company. I had the privilege of, in fact, representing the client in this company, in this matter. So what had happened is, in the background that I'm sitting is that the learned NCLT had, in the petition of two home buyers, directed the initiation of CIRP and appointed an IRP for Umang. So our clients was the Flat Buyers Association, who had also filed a complaint before NCDRC, comprised of home buyers who were inclined to have the project completed in a time-bound manner, since there was already a delay of more than 4 years, and it was prejudicially affecting their finances. So we, on behalf of the association, felt prejudiced by this order that was passed by NCLT. And so though we were not a party before NCLT, we filed an appeal before NCLAT. So where we had the privilege of appearing before Honorable Mr. Justice Mukhopadhaya, he was the Honorable Chairperson then. And there was an interim order passed, followed by a final decision of February 2020, where he passed an order for reverse insolvency. He clarified that CIRP against a real estate company is limited to a project as per approved plan by the competent authority, and not other projects which are separate at other places, for which separate plans approved and further directed that one of the promoters of the corporate debtor should cooperate with the IRP and disburse the amount from outside the CIRP process as a lender in the capacity of financial creditor, to ensure that the project is completed within the time frame as specified by the NCLAT. So this finding of NCLAT is much in consonance with the practicalities of the real estate projects, which are also reverberated in the IBC Amendment 2019, which specified that for financial creditors who are allottees under a real estate project, an application for initiating the CIRP process against the corporate debtor shall be filed jointly by not less than 100 of such allottees under the same real estate project, or not less than 10% of the total number of allottees under the same real estate project, whichever is less. So which implies that even legislature recognized that the initiation of CIRP must always be specific to a project and not of the entire corporate entity of the corporate debtor. So that was a landmark judgment, sir, according to me, and there was no such concept of reverse insolvency which was thought by the judiciary before that. So in this context, may I now invite Honorable Justice Mukhopadhaya to share his thoughts behind this remarkable judgment, as well as the entire concept of reverse insolvency, the way he had developed in the judgment, and the way he had thereafter put it across in the judgment in the manner in which he did. It is a brilliant judgment. When we read it, there were a lot of diverse views on it, but I would want to hear from sir on this aspect a little more, sir. Over to you, Honorable Justice Mukhopadhaya.
Good afternoon to all of you. Actually started with the first judgment in Nikhil Mehta and Sons versus EMR Infrastructure.
Yes.
That was the first judgment where it was held by the NCLAT that the allottees, with the flat buyers or shop buyers, they come within the meaning of the section 5(7), read with section 8, subsection 8. After that, the clarification was made, we say by way of amendment, because judgment was already there on the basis of the provision of law. Now, provision of law is there. Only thing that was clarified by the government that about the allottees. But there are various problems which started actually when originally we were dealing with the insolvency cases. Insolvency cases were going on in one manner, maximization of the asset of the corporate debtor, balancing the stakeholders, maximize the asset of the stakeholders also. So all those theories were settled and established. But things changed after the judgment of the SR Steel by the NCLAT. When SR Steel judgment was delivered, there was a huge hue and cry amongst the bankers, I won't say financial creditors. Bankers, they thought that all the bankers are secured creditor, and they thought that we are above all. Now I am no more a judge, but I have a right to criticize some of the judgment of the Supreme Court also. Supreme Court had taken into consideration all the earlier judgment and lay down the law practically while upholding its in Swiss relevance. But Swiss relevance, up to that, there was no problem. First problem which was in my mind is that viability, feasibility, and other things which is prescribed under the law, who are the best persons? So I asked question to many people. Is it the industries and the business houses? They will understand the viability and feasibility or other aspect of a corporate, or the bank will understand. So according to me, my personal opinion, operational creditors are not chayawala or samosawala. They are all industries. They are business people. They understand the business, place of business, type of business, its feasibility, viability. They are the best person. Bankers, what they understand, that whether these people have capacity to pay back. So still, my personally speaking, the operational creditors must be in the committee of creditors. It must be met by the government because they are the person who knows about the corporate, that how to run a corporate. A corporate which is going for infrastructure company, I am giving you. Here, when we were talking of flat wires, it is one type of infrastructure. But the infrastructure, a road, land belongs to the government. Investment is made on the road. What will be sold? Who will be the financial creditor? Who will be the operational creditor? Is one thing. But how to go ahead with the infrastructure like construction of a road? So infrastructure is not only these houses, building, etc. Also the construction of the road which are to be laid because of these houses, etc. and the public facilities. So while giving thought in this process, ultimately, in any case, Supreme Court judgment is binding. I used to cut a joke. The joke was that I am Harvard returned and they are the student of the Harvard. That means they will have to learn, Supreme Court judges will have to learn. I have returned from Supreme Court, but their judgment is binding. You know why I am saying so? See the problem. Some of the problem I have highlighted, many of the problems I have not yet highlighted, I can highlight today. Now, financial creditor, the moment we say of these allottees, have they got any idea about commercial wisdom? If they don't have any idea of commercial wisdom, which is a new word added by Honorable Supreme Court, starting from innovative, that commercial wisdom is of the financial creditors. I doubt how that can be matched in the case of these cases. There are cases where there is no financial creditor and only operational creditor, and the law says that the operational creditors will be the member of the committee of creditors. Then how they will be understanding? So a general, if you look into the earlier judgment of the Honorable Supreme Court, for the purpose of lawyers to argue and point out in future, it was presumed that all financial creditors, they understand business, they have the commercial wisdom, and operational creditors do not understand, which according to me, operational creditors, they understand. For example, this building. Now, infrastructure, when you are going on, what is being mortgaged? I found a castle in the air was mortgaged by the bank. You understand? 8th floor not constructed. An agreement reached with regard to agreement, 8th floor. And a bank mortgaged the 8th floor which is not there. So can it be stated to be a mortgage of a property which will be coming in future, a castle in the air? So these are the things yet to be answered. Then who are secured creditor of whom? A bank is giving a loan to the corporate for land. He may be a secured creditor with regard to the land, but not the buildings. Now, the other financial creditor, they are giving for a particular flat, allottees. Now, will they be secured creditor? No, they will not be secured creditor. So they are unsecured creditor, financial creditor. Banks are secured creditor. So one way of looking into that, after amendment of subsection 4, if you say give it to secured creditor, will the banks will be given the flats? Is it meant for them or is it meant for unsecured creditor? Second thing you can look into, a company will remain as a going concern. How the company will remain a going concern with regard to a project? Maximization of the asset. So it was thought that maximization of asset means maximization of the asset of that particular project. Company may be X having 3 projects, one at Kerala, another maybe in Delhi, another Noida, and somewhere in Bombay. Everywhere, financial creditors are different, operational creditors are different, but corporate is common. So can there be a corporate insolvency resolution process against the corporate? And if it is there, will it hamper the other project? Now, we'll have to maximize the asset of the corporate debtor, that means of the company, or maximize the asset of the project. That means the project which is going on, the flash value, which was 70 crore, is today 50 crore. 1 crore is 70 crore. So time value of money does not mean it is something more, maybe less. So time value of money, we know the time value of money, but we don't give a value to the time. A day has come to understand time has the money value. Therefore, time value of the money, the word which has been defined in this section. And look into this matter, that 180 days. Now, SR Steel, for example, SR Steel was producing steel during going concern. And they sold the steel, their steel also. RP, under the guidance of the RP, they used to sell it, the products. There is a profit of more than 3,500 crore. Here, which product will be sold? The product is the flat, shop, those are the products. So how it will be sold? The selling means you will have to do the registration. You will have to complete it. If you complete it, get the certificate from the authority and register it, then it will be a going concern. And during the going concern, you will sell the asset of the company, which is the product of the company. Not the company's asset, but the product of the, which was not there. You understand? What is product of the asset? Now, a company is manufacturing steel or a car, they are the operational creditor. They are selling their product. The product of a corporate debtor with regard to infrastructure company are the flats, are the shops. So those products are to be sold. So if that is sold by one, how as on the date of initiation, RP will be finding out what is the asset value. Now, asset value which will be calculated for a third party to come, by the time he will be filing a resolution plan, many flats will be sold. If many flats are sold already and the party gives a plan, then what will be the position? Therefore, there is a time gap between the initiation, calculation of the asset of the company, which may be 0 on the day, which may be 10 on the day, and the asset will grow during the corporate insolvency resolution process, which is not known that how many floors will be constructed, what is the value of the asset will go up. So information memorandum will be practically a blind lane through which the resolution applicants are to trouble, because they don't know what will happen. I'm giving you an example of JP infrastructure, of Amrit. You give it everything to NBCC. NBCC may give it to the allottees. What about the banks? What about the roads? Who will construct the road? Who will be spending money? How the NBCC will collect the money? 142 is different, but IBC, according to me, in the matter of IBC, 142 should not be applied. 142 is not the answer for the purpose of infrastructure company of the allottees. Now, every allottee may not be, but a large number of allottees are taking a loan from the bank. They are mortgaging their asset which will come to them in future. And they are bound to pay the interest every month. Now, if they wait for the resolution process to be completed, so during this 180 days or 270 days, they will have to pay the interest to the banks. There may be a default on their part. Now, they may be personal guarantor. Now, these types of problems which are being created. Now, you cannot sell the asset of a corporate debtor. Here, you will have to sell the asset of the corporate debtor. So here, company to be remain as a going concern means you will have to complete the project and give it to the people. Then what remains for the resolution applicant to come? So who are to give? Now see, the financial creditors, they spend money to keep the company as a going concern. Here, flat owners or buyers, they will never invest further money. Why they will invest money? They said, we have already given 70 lakhs. We have given 80 lakhs. I will not be giving anything more. I will be giving it when it will be completed. So those things were sorted out, which you have find in the Flat Buyers Association of Intelligence. So first was a judgment of Nikhil Mehta and Sons holding that they are financial creditor, followed by amendment of the law or clarification of the law, explanation there that they are financial creditors, upheld by the Honorable Supreme Court that they are financial creditors. There is a judgment of Nabeen Reheja. Nabeen Reheja versus Shilpa Jain and others. In that case, later on found that the Shilpa Jain and others, they also joined hand with the other allottees. Allottees were not happy. Two persons, they triggered. Now suppose a tower A and B is complete, and for tower T, C, somebody triggers, A and B people will suffer. So Nabil Raja's judgment, we clothe the infrastructure companies with the arms to show that in which cases there will be no initiation of corporate insolvency against those who can complete a little beyond time. Right. So there we have given a mileage, in a sense, that which are not in the hands. I won't say God's act, no, which are not in their hand. For example, if steel production is not going on, if supply of raw material is stopped, if the sand is coming from some of the, if they are stopped, where is their fault? Where is the fault? If the matter is pending before the government for the purpose of approval of the fire safety, yes, or of the granting, then why they should suffer? Why there should be? So that judgment was given to show that these are the circumstances in which there should not be any corporate insolvency resolution process. If they survive, you know, I think 80% of the workmen are in the unorganized labor sector. I'm from Bihar, basically. My people from Bihar, they are in these organized, unorganized sector. They understand cash money. I'm giving the practical now, certain knowledge. So all black money used to be given to these laborers. Now, if you go to the market, you may find nearer to Delhi only 2 mines which have been given permitted. 8 mines are illegally mining sand. Because of 8 mines are illegally mining sand, the infrastructure is going on. If they go for 2 mining plants which have been granted license, then there will be a delay. There will be a cost escalation because price variation in the mines which have been given license, which are 2, in comparison to the 8 who have not been granted a license, their price variation is less. Similar is with regard to stone mines, illegal mining, legal mining. These infrastructure companies are based on them. Because without that, the reality is that they can't construct. The supply will be less. These are the practical difficulties. If you talk to the infrastructure company, they are facing. The cost they may have made in a way that how much they will be purchasing from XYZ. Now XYZ, if they are illegal mining and stopped, then there will be an effect. Similarly, banks, they are charging from the allottees. Now, allottees is going on paying, but they don't know when it will be completed. Now, if you wait for a third party to come, who are known as a resolution applicant, then they will come and they will say, I will take another 2 years. For example, MBCC has said, I will take 2 years, 3 years, 4 years. So you waste 1 year in insolvency, another 2 years you give to them. But if you ask the developer, he may complete within 1.5 years. So these are the practical sides which are thought for, and we found that judgment of the Committee of Creditor of SR Steel is coming in our way. They say distribution first secured creditor, but here distribution will be to the unsecured creditor. Unsecured creditor means flat owners. Secured creditors will never take flat. Their asset cannot be sold. Here, asset is required to be sold. There, you wait for the resolution plan. Here, it is not desirable to wait for a resolution plan. So everything is in a reverse gear. Therefore, NCLAT ought to tell it as a reverse corporate insolvency resolution process. Your main object is maximization of the asset of the corporate debtor. Means maximize the asset of the flats and the shops. If it is 70 crore, let it remain 70 crore. It should not come down to 50 crore. Party has spent 70 crore or 70 lakhs or should not come to 50 lakhs. I know party has given for 1 crore 7 lakh for a flat and they have given 90% of it. Now they want money back with interest, which is coming to 1 crore 20 lakhs. And if the owner sells the house, you won't get more than 60 lakhs. So will the owner pay from his pocket? Second thing, if he releases all the allottees, then what remains?
Nothing.
If all allottees ask for refund of the money, then what will happen? You'll be losing the allottees. Fresh allottees means you will have to sell in a lower price. These are the practical problem with regard to the infrastructure company, and they are bleeding. If they bleed, maximum employment is generated by them. Unorganized sector is living on them.
Correct. So allow me to, very futuristic stuff.
Banks are living on them. Pradhan Mantri Griha Yojana is also based on that.
Exactly. In fact, I was just about to bring that in.
Pradhan Mantri Griha Yojana is there, and there is no Griha, but there is a Yojana. And you start an insolvency to sell that flat which is not there.
You have absolutely got it. You've hit the nail by the hammer exactly where it.
I think I thought, and my brother said in the NCLAT that let us discuss after your retirement. But I find that I demitted my office on 15th March. I am sitting home. The whole over India is also sitting along with me. So we could not discuss, but time has come to make it understand to those who are the members of the NCLAT, NCLT, and maximum it requires understanding of the Honorable Supreme Court judges.
Yes, sir. Absolutely. In fact,
power under 139, if you look into Article 139, somebody who can go to the Constitution of India 139.
Yes.
139 says that Parliament can give power to the Supreme Court to issue certain writ, order, direction in the nature of so and so. Same language like 226. For any other purpose other than Part 4, Part 3.
Yes.
What 142, they are exercising same power, which power has not been given by Parliament under Article. With regard to House, where is the Article 32? Where is PIL? How it will be a PIL will be maintainable? Is it a fundamental right? How a PIL will be maintainable under which law? So, if at all maintainable, it will be after NCLAT. Appeal will be maintainable under the insolvency. not the 32. 32 is a fundamental right.
Fundamental right. That's right.
And no person has fundamental right over any property, even on the land. So I think time has come for deliberation, not only amongst the corporates who are in the infrastructure. Banker must understand that they should survive. Government must understand that they are bleeding.
That's right.
Exactly. They are bleeding.
Exactly. Bilkul.
They will have to give, like this COVID time, you will have to give that, what they call it, for the purpose of giving
relief measures.
No. The oxygen they give.
Oxygen they give, yeah.
Now they will have to be given oxygen. Ventilators is to be given to these people. A ventilator for the purpose of their living.
That's right.
Why I am saying 25,000 crore was earmarked by the government. I had a discussion at that time with the ministry people, the officers. They asked, sir, how we'll be distributing it? I said, find out if you can distribute it to those who are already facing the insolvency. Find out who are to face insolvency. So pocket of a corporate debtor is to be seen. RERA, etc. has taken care of many things. But now it requires a new look, a new thought. And it requires further development. Not only the Flat Buyers Association Winter is only some sort of solution which has been shown because of the problem maintained therein. But a solution to be given. That's that right. The resolution applicant must be so who will invest money first.
Correct. That kind of a commitment.
Initially, at this time of the initiation, whoever invests money, maximum money, he will be the resolution applicant, right. Not in the end, but correct. In the very beginning.
Correct.
Certain change is to be made, reverse system is to go, resolution plan is to be approved. What is resolution plan? Plan of the building is there. Who will fund?
Correct.
You come. Whoever will agree to give maximum fund and complete it within the minimum time, they should be accepted as the successful resolution applicant in the beginning.
Right.
And under the RP's control, they should be allowed to complete till end. I think this is how this can be sorted out.
In fact, yes, in fact, you have answered so many questions futuristically as well. And in fact, I wanted to summarize this in a few lines about how it is important to keep sustainability of a sector, sustainability of all the stakeholders at the center point in kind of handling a very critical area like real estate, particularly from the housing perspective. And but you put it beautifully, so I'll not even make an attempt to summarize it beyond that. So, in fact, allow me to, at this stage, you very rightly referred about the Pradhan Mantri Awas Yojana, which is a very aggressive program considering the population and the diversity that we have. And particularly after pandemic, after the COVID-19 scenario, the Prime Minister's call for Atmanirbhar Bharat, the Ministry of Housing and Urban Affairs was very swift in rolling out under the Housing for All initiative, the Affordable Rental Housing Complexes scheme, is essentially curated to provide housing for the last person in the value chain, the low-income group people, the migrant laborers in the urban areas. So this is essentially an urban scheme, sir. And as you rightly said that these bleeding companies need support, they need oxygen, they need to be given the crutches to not only walk, to fly, because some of these land is not a fundamental right because it's the doctrine of eminent domain, and principally because everybody's housing needs to be met. and not to be misused for profiteering or those kind of objectives by certain stakeholders. And that is why the entire mechanism of RERA is already in place, and therefore NCLT has a very unique role to play there. And we see this symphony, which is very necessary to play out over the next couple of years. May I now invite Mr. Amrit Abhijat, Learned Joint Secretary and Mission Director for Housing for All with the Ministry of Housing and Urban Affairs. May I request Amrit ji to kindly outline the ARHC scheme, its essential features, particularly the objectives, priorities, opportunities, and also the challenge mitigation initiatives built into the scheme itself to incentivize and encourage private sector participation. Under both, there are two models. I'll, of course, allow, instead of me giving an outline, I'll request Amrit ji to kindly take it forward from here with a keynote address. Over to you, Amrit.
Good afternoon, everybody. Thank you very much. I'd like to thank Justice Mukhopadhaya for a very insightful analysis and an argument on the real estate and as well as on the insolvency code. And thank you, Manoj, for inviting me over, my dear friend, and your entire team. And I'd also like to welcome all the participants who are on this Zoom meeting today. And it's, of course, a very interesting thing that you've done, and I would like to interact more with this entire sector so that there's more and more awareness on the issue. I'll base my talk in three distinct parts. Since I earned my bread and butter from the Pradhan Mantri Awas Yojana, I'll be speaking briefly on that because this is perhaps one of the largest housing programs that we have in the world right now. Thereafter, I'll come to the ARHC features and subsequently discuss in detail how it makes more and more sense for the private entities to look at the affordable rental housing complex as an extremely viable option in housing, and also how both social and economic motivations may be addressed. So coming to Pradhan Mantri Awas Yojana, this started in June 2015 with the clarion call given by the Honorable Prime Minister from the ramparts of the Red Fort when he said in the August month that the Pradhan Mantri Awas Yojana would take care of the housing needs of the entire country, and the Pradhan Mantri Awas Yojana Shahri and Gramin both were started with an initial target of 5 crore houses to be built in both rural and urban India. We had an overall target of about 2 crores at that point of time, but based on the demand assessment, which was a very unique strategy, we adopted to assess the demand rather than it being forced upon people or through some kind of a census assessment. We gave it to the people to decide for themselves what kind of a house they required. So the present demand came to about 1.12 crore, which is dynamic in nature. We started making these, sanctioning these houses. It was based on the spirit of cooperative federalism, where the states were allowed to decide on the land, on the structure, on the beneficiary list, on their DPRs, the approval processes, everything. The central government only intervened and perhaps looked at the scheme, whether the scheme is being followed in terms of the broad rubrics of the guidelines, and also the funding requirements and other kinds of backward and forward linkages in any product or a project. Say, for example, the sewerage and the electricity provisions and trunk infrastructure like roads, etc. We started off gradually after about 6-7 months when the initial structure and training and stuff were given out. From a modest start, we became very aggressive, and I'm happy to say that out of this 112 lakh houses, we have sanctioned 105 lakh houses, which is like 1 crore 5 lakh houses plus. It's actually 1 crore 7 lakh houses today. And out of that, about 67 lakh houses are being made right now, out of which 36 lakh houses have been completed and delivered. To just share a perspective, this is about 8 times the number of houses the earlier program in the name of Jawaharlal Nehru Urban Mission could achieve in terms of sanctioning, and about 4 times already in terms of delivery in its 5th year of existence. I would be very happy to share this in 2022, what the overall statistics indicate. But more than the statistics, I myself and the Honorable Minister from our department and certainly the Secretary and all of us within this large team that we have all over the country. It is absolute pleasure to meet the beneficiaries of PM houses. You can go all over the country and see the kind of impact and change and the kind of dignity that this kind of a housing program has brought about. Because quite unlike the earlier schemes where the normal given area for a project was about anywhere between 18 and 22 square meters, this went on till 30, and we also give it out to the people of this country that the states can decide on a much larger housing also, given the priorities of the clients. So this gave a huge amount of shift in the way housing was looked at for the first time, where from some kind of an incidental housing mechanism that we would help some poor here and there, it became a comprehensive program where both rural and urban development ministries went on to address this housing demand in a very, very comprehensive manner. And we are very happy to say that if there are any additional demands that come forth, we would be able to do it. One very important reason why I think this is succeeding in the overall legacy of things that we see it, I think that the cafeteria approach that we adopted into giving the houses, wherein you had a solution for somebody who had a piece of land, you had a solution for somebody who did not have a piece of land, but yet was staying in a city and needed a apartment-like structure, or whether it was slums, or perhaps also for the open market where the real estate really comes in a big way, that credit-linked subsidy, which was the fourth vertical of PMAY, wherein the state wasn't really involved in a big way. It was a central support scheme where we would give about 2.67 lakh rupee to any buyer who was eligible under the CLSS through the bank settlements. And it was between the banker, buyer, and the beneficiary. This we have already done about 11 lakh cases, and these houses primarily are made by the private sector. So it created a huge demand within the affordable housing segment also for the builders, those who were making houses for the affordable segment across various cities in the country. So that's about it. We are making huge inroads into technology also. The Honorable Prime Minister was very kind to inaugurate the Global Housing Technology Challenge, after which we brought in 54 types of technologies from the world over. And we are coming up with the lighthouse projects of many, many different kinds of technologies, because given the fact that we have the land, we have the demand, we have the builders, we would need a huge ecosystem of people who are trained into new innovative technologies where we can save on time, cost, and also the environmental issues that come along with it into making into a brick and mortar kind of a thing. So this so much should suffice for the Pradhan Mantri Awas Yojana. And if there are more questions, I would like to take that later. From within this scenario emerged the new reality that we are all undergoing, the huge impact of the COVID pandemic that was witnessed since the middle of March, and we are still undergoing that. During the pandemic and when the initial lockdown was announced, we saw that a large number of workers and urban poor was reverse migrating from the cities to the villages, going back to their own fields, whether in Bihar, whether in Uttar Pradesh or down south. They did not have the industries were shutting down, the manufacturing units were suffering, and there was this despondency developing, and people were actually walking up through the national highways that we got to see. This got us thinking that if they had a house of their own, like you and me, and if they were staying in some kind of an arrangement, perhaps they would have made, some ends meet, and with the security of a house being there, this solution would not have been, like this, and they wouldn't have really to walk back. This became a very important push factor for a realization that the ministry already had for a very long time to do something on rental housing space. I'll come to that a bit later of what is the ministry doing on the rental housing market, because that is a huge sphere of concern on the Model Tenancy Act. But we took a cue only for the urban migrants and poor from this, and we told that let's devise a policy wherein this kind of a migration, this distress is not there, because it not only affects the people who are migrating, reverse migrating themselves, but also is the economy is being very adversely affected, because after all, within a month's time, a large number of units did open up also, but they are still now coming back from the rural areas. So people like me, like who are staying in government houses, we never went back to our houses because we had the security of this, and otherwise we would also be perhaps in that situation. So we came up with an affordable rental housing complex program after due deliberation from the stakeholders, NAREDCO, CREDAI, FICCI, SHM, you name it, also all along the states. And we devised this sub-scheme under the Pradhan Mantri Awas Yojana, where we told that the migrant poor and the urban poor would be given a place to live in the city. One basic transition that we brought about is that for last 70 years, we've always been pushing ownership housing, despite the fact or in spite of the fact that the person may not be in a position to really buy or was not motivated enough. So we opened the gates of the rental market within the government schemes, and this was one big initiative from ownership to rental. Then we told that who could be benefited. So instead of relying on a very narrow-based definition of just the labor, we told who are migrants. The migrants are not only the laborers. The migrants are also students who go to study in Kota or in Lucknow or in Delhi. The migrant is also a health worker who is working in a hospital, say Medanta. A migrant is also a market salesperson who is showing things in a jewelry shop or a cloth market shop. Because eventually all of them survive on a low scale of about 2,000 to 3,000 rupees rent, or maybe 4,000 or 5,000 rupees, depending on the city. We told that we will take a very broad view, all such people, those who are migrating and belong to the EWS section of, as defined in the PMAY, having an income of about 3 lakh rupee or more as a household, would be eligible. And the only thing that we would require is some proof where they can say that they belong to the EWS. So that is something we brought about. This ARSA scheme was to be made operational immediately, and it would go on till March 2022. But if there are projects which go on beyond that, I'm saying, when, what is the time period, they will also be entertained because the projects have to be completed. It will apply for all the statutory towns, all the notified planning areas, all the development authorities. And if there are peri-urban areas which may be classified as village as on today, can by notification be increased into and be brought under a planned area or a special notified area. As Manoj was referring, that this is a model, ARSC model will have two models under which we will work. And I'll explain model 1 in brief and model 2 in detail, because that is what is a matter of great concern today. Model 1 is essentially wherein we have houses from earlier schemes, whether center or the state, which have not been occupied on account of various factors. Say, for example, price escalation, site not being good, transport arrangement not being there, run down over a period. Out of this, we saw that we have about 109,000 houses under the erstwhile JNNURM scheme, which were not occupied. Say, for example, we have about 31,000 houses in Delhi alone, which due to the transport arrangement or perhaps them being in areas which were not very attractive, are lying vacant. But during the 10 years, what happened? These areas are increasingly coming within the city. But now that the houses have become run down, or there is a window pane which is broken, or a water connection not being there, nobody is interested. Despite the fact that they are, within the last 10, 15 years, they are coming closer and closer to the city because the city is growing. Also, we have cases of Maharashtra, Uttar Pradesh, Tamil Nadu, where these houses are vacant, maybe 3,000, 10,000, state-wise differs. Also, there are a large number of schemes in the government sector in the states. There's a government which says we will have a Kanshi Ram Yojana, then there's a government which says we will have a Lohiya Gram Awas Yojana, depending on the kind of, the naming the states governments may prefer. But there is a huge pool of houses which have been made by the state governments also. They have not been occupied. So this was model 1, where we told that let there be a private entity who will bid it out. The state government, the urban local body will fix a nominal rent. And any bidder who says that they will be taking rent and the amount which will be invested by this entity, the person who wins the bid is the person who says that we will be paying back the money as soon as possible with the lowest possible rent. So the lowest possible rent, and as and when you are able to recoup the investment that you've made, you will then share the profits with the urban local body, which can be fixed mutually. Say, for example, you have a Karkarduma residence of JNNURM. The overall investment may take about 2 crores for it to be retrofitted. We have a RDOT model. We say you develop, you retrofit, you operate, and you then transfer. So this 2 crores, say there were 200 flats. These 200 flats will then be divided on the rental basis. And if the entity is able to make up for the investment that he's made either through bank or through his own resources or through a consortium or through a group of people, he's able to recoup it in the fifth year. So the sixth year onwards, they share revenues of profit within the entity and with the urban local body. So urban local body also benefits, and they run it for 25 years. Now I come to Model 2. Model 2 is much more comprehensive. We said that any place, any industry, any association, any private builder, anybody who has a piece of land or is able to get one on basis of concessionaire agreement or any agreement that they may arrive, parties can join hands. If they have a piece of land, they go to the state government and they say, we are interested in making an affordable rental housing complex. Now let's take a scenario where let's take the example of Medanta Hospital in Gurgaon. They have the permission to run the hospital within the Act, as provided in the development authorities, this thing. So they say that we will make 500 rooms. It will apply for pathologists, technicians, people in the food industry there who are running the mess, doctors, nurses, other technicians, ward boys. Suppose there's a 500 population. They come from different places. They are constant in terms of resources, coming all the way 20 kilometers, 25 kilometers, environmental damage, traffic arrangements, making ends meet, returning back late in the night. We say that you can house them at the hospital itself. What we provide as government is certain incentives so that it becomes very possible for the unit to do this. Normally what happens is we give you a permission for land, but use permission is not given. Use permission is only for hospitals. So we extend this use permission, that's one. Second is that if this is made with new technology, as an innovative technology, we give a grant of 60,000 for a single room and 1 lakh rupee for a double room. In addition to that, the income tax and GST on it is waived off entirely. In addition, what we also do is that you have an assured clientele already, because you can have either your own people, you can also take it from any neighboring area on the basis of a rental arrangement. What the state government in addition gives is an FSI of 1.5 over and above, which is free. They also provide you trunk infrastructure. They also provide you municipal charges only at residential costs, not at commercial rates. What eventually happens with this initiative is that your IRR, the net return on your investments, is close to 12 to 14%. And 12 to 14% over an investment in today's climate, when so much is happening already, is a good investment model. It may, this is of the one-time calculation. It may actually go higher up. It may marginally come down depending on city by city, location by location. But we did a lot of maths across various cities with this arrangement where you are able to get these facilities. And one additional, then we topped it up with a definition within the harmonized master list. We went to the finance ministry and we told that the people, those who are investing, must get loan at cheaper rate. This was allowed from the priority sector lending, and the loan which will be given for the private entity through the banks and the HCCs will at least be 3 to 4% less than the ongoing rate at that point of time. So when we went to the cabinet, the on-lending rate was normally about 10 to 12%. We thought that it will come 8%, but now since the banks are flush with funds, it may marginally change, but these will be able to get at a much lower cost still. So lower rate of interest, incentives in terms of technology innovation grant, incentive in terms of GST and income tax. Then you had an incentive in terms of FSI. You had land use permission changed. You got assured clientele. You had trunk infrastructure. This model that we suggested. Normally what happens in government, whenever we ask departments, give land to us, we want to make quarters for the poor, we want to make it under some scheme of maybe Pradhan Mantri Awas Yojana. There's no land readily available. Either if it is available, it's on the fringes. So the private sector is just not able to invest because it was not allowed or encouraged. This model encourages, it creates an ecosystem wherein the private investor, if you have a piece of land or an existing unit of an industry, say for example, somebody is making tires, the industry is not running very well if right now. they say, okay, we'll do this also. So you get an additional source of investment within this given period. So you can invest, you get incentive. There is a win-win situation. And that win-win situation is that that worker who was coming all the way to the tire factory, or that investor is now able to take care of the persons who are working and adding to the productivity also. Therefore, there is a social component we are addressing. There is a private interest component of profit component that we are addressing. And the government is very happy because it is not again investing in some kind of a venture where government is the sole arbitrator and the sole provider. The plate becomes much more larger. Because how many houses can we make for the labor, frankly speaking, in the government? A few lakh, maybe a couple of more lakhs. But this will then take a very long time. So why not make a situation where 100 flowers bloom, where the private entities are able to partake and take the responsibility as nationalist Indians also, and also invest and earn and be happy. So it's a win-win situation where the government is happy that they are able to provide an ecosystem wherein laborers are provided housing not only from the government schemes but also from the private entity. The migrant or the urban poor is happy because they are able to get rents at about 2,000 to 3,000 rupees, and they don't have to compete. They don't have to always own a house. And the entity is happy because it is doing a socially productive work, also getting money out of that. In addition to that, I'll just add one or two more points, is that this entire ecosystem will be on the website. We are on that right at the moment preparing for it. It has absolutely no bureaucracy. We have told that 30 days time, if projects are not cleared, they will be deemed to be clear by the state government, and they have to come to the central government only if new technology is being adopted. If they're doing it through the original brick and mortar, they don't have to come here. In addition to that, the other situation is that we will also have an accreditation system wherein these ARSCs, suppose it spreads in the country like wildfire, we'll be very happy with that. There would be A grade, B grade, C grade. So you, the beneficiary, will actually be able to say, no, I don't want to stay here. I want to go there because they offer better water facilities. It's very clean and all that. And it will be managed through aggregators. Individuals are not being preferred because somebody may not be able to pay rent and he might just disappear one day. So we are trying to tie it up with the salaried arrangement from within the industries, or there is an aggregator, maybe like private domain, where somebody is, an agency is there to manage the entire rental arrangement. We are also encouraging people who in the food and beverages industry to run their mess, or for a transport arrangement or a school arrangement. It will be knit into a manner wherein various other professions are also impacted upon, so that it helps the backward forward linkages also, and are able to realize people are able to get into more and more productive economic ventures. So that's about it, the overall model of the affordable rental housing complex. Next month, sometime early, we will be coming with an expression of interest, because we've asked the state governments to sign a memorandum of agreement. We've received a large number of responses from them, and you'll be very happy to note that we did a video conferencing last month, wherein without the expression of interest, there are at least half a dozen parties in various state governments which are saying that we are very excited. When are you going to do it? And we have land and we want to invest immediately and get on with it, so that we are able to provide residences early as possible. So all in all, this is what I had to say in brief, and then I'd be very happy to take on questions. Thanks, everybody.
Thank you so much, Amrit, for such a detailed outline of the affordable rental housing scheme, and also indicating the successes of the Pradhan Mantri Awas Yojana so far. In fact, before moving on to some very key questions on legal and regulatory challenges that the real estate sector is facing, perspectives from our colleagues leading the legal, regulatory, and policy teams with some of the flagship companies, may I request, I'll try and reach out to our colleagues on the panel here, and about your just staying with the discussion on the affordable rental housing complexes scheme for a moment. May I request your observations, any concerns you have, anything you still seek to look out for, because it's half a dozen so far, but the kind of objectives and the kind of motivation behind the scheme, I think there needs to be a lot larger number and bigger outlays across the country. Over to you. May I start with Parveen? Some thoughts, some observations, some concerns, something that we can answer here, something we can answer and kind of find a way after the discussion as well. Over to you, Parveen.
Sure. Thank you so much. Thank you, Justice Mukhopadhaya, and we've had a wonderful discussion. Thank you for explaining the PMAY and the Affordable Rental Housing Scheme also. What I'd like to say is that I think it's a wonderful initiative and it's a really welcome move. Probably is going to develop a little more in certain areas because a lot of calculations have taken place on the IRR basis of full or a high occupancy, which may not be so, which leaves room for a margin where there could be gaps on how a company could recover their investment, since the investment is to be recovered only through rents. So whether the government would consider taking a fixed rental for a particular amount if there is a drop in the take-up of the properties. Also, I think, and maybe because this has been very peculiar to India, where the private development takes place sometimes at a much faster pace than the trunk infrastructure. That really does impact the sellability of the project, and in this case, the rental scheme itself. Therefore, at least when I read the scheme, and maybe I'm not familiar too much with the other details which were not available, the timelines for completion of the trunk infrastructure need to be specifically committed to by the government to be in consonance with the timelines by which the project is expected to be completed. Therefore, there is some safeguard to what rentals and projections have been calculated, the possibility of that really coming through. Also, I think one of the provisions says that if it's not completed, the project within the timelines, the investments and the grants which have been made, those grants could be recalled back with interest. But like any contract, I think it would still need to provide the way even RERA provides for, where it could be force major issues or due to any third party or statutory requirement or any court order not permitting it. And those exceptions may need to be considered to be carved out to make it a fair playing field and even more attractive proposition than what it already is. In Model 2, where the land also needs to be bought or contributed as part of the entire capital cost, the other area of possible discussion could be whether land could be given, like we have seen over the years, at a subsidized rate or a staggered payment to be made to the government, or whether the Land Acquisition Act, could be used, for that, so that the capital investment is slightly reduced, and again, thereby making it a larger implementable scheme. So just very broad initial observations on the rental housing scheme, and thank you so much.
Amrit, would you want to respond to some of these, or maybe collect some more thoughts and then do it in one go, as you prefer?
That'd be fine.
Yeah, so Gopalji, may I reach out to you for your thoughts on the affordable rental housing complexes scheme? How do you see this as an opportunity, challenge?
Indeed, very, I would say, encouraging. In Maharashtra or in Bombay itself, we had the rental housing scheme which was in place, which encouraged the developers to allocate a portion of the land for construction of the houses for rental housing purposes, which in turn were handed over to the MMRDA, and against that the developers were able to get an additional FSI. But I think this scheme that has been formulated by you and the central government is a tad better than what is otherwise available, because two additional things that are being made available, I would say. One is the trunk infrastructure is being developed at the cost of the state government or the planning authority. And the second thing is that the developer is able to monetize it. But I think before we can go ahead with this kind of a proposition, particularly in the context of Model 2. I would not want to delve much on Model 1 because as a developers, they would be having reasonable amount of land available to allocate for ARHCs. no doubt about it. But it will become necessary for the central government to impress upon the state governments to modify or amend their development control regulations to bring in this as a chapter, legislate it, make things clear. And taking a cue from what Parveen was saying is that if these things are legislated, it makes things clear. There is a level playing field. People know very well where they stand, and legislation also helps in the way that if there are any misdeeds or misdemeanors on the part of the developer, as also on the part of the tenant who occupies it, there is a remedy that is available both to the government as well as to the developer to make the best out of it. Yeah, I think I would like to leave it at that. And just one thing on Justice Mukhopadhyaya's, observation. The most important thing that this judgment, tries to bring in is that the company must go on. It must go on as a going concern. And that is really relevant because it helps not only meeting the expectations of the home buyers to get their homes, but also, a way to generate employment, generate funds, and so on and so forth. I think I would like to close it at that.
Thank you so much, Gopalji. We'll just come back to the insolvency bit in a few minutes. Just staying with the affordable rental housing scheme. Amrit, over to you. Would you want to just have some observations on initial thoughts? Or we could, of course, have discussions later on as well.
Thank you very much. Both for Parveen and Gopal, the good thing is that the answers are yes. Okay. So in terms of trunk infrastructure, yes, I think that Parveen has rightly flagged that it should not happen that the building is ready and the trunk infrastructure is not, which is why the state governments are taking time. It's about a month when we floated the cabinet decision was sometime in the month 27th of July, if I remember right. So it's been about a month, but the state governments are looking at it very seriously because once a commitment made and an MOA has been signed, they get tied down legally. And that is why they are going to the cabinet, they are going to the chief minister's office, they are looking for budgeted information where in this commitment is then realized. So that's there. And if rents are not enough, I must add that there is also a sale component of 10% commercial area that is also been inbuilt. And when you decide on the rents, it is along with the urban local bodies, but then you have the initial rent that you can raise it from time to time. It's not a fixed rent. And, you can raise it by 8% every 2 years, something like that. So that's there. And you would be able to monetize. Suppose there's a large piece of land, you can make something apart from this also, which may not be funded by the technology innovation grant, but you can of course cross monetize it. That's not a problem. So these things are there. And in terms of force majeure, in case the project does not finish off on time, that will always be there. That has to be inbuilt within the RFP and the OI, because say for a situation like COVID, we will have to obviously look at it. But the 18 months time window that we have asked for the projects to be completed does not apply for every project. It only applies for when we give the TIG, the Technology Innovation Grant, because you would be aware that anybody making a building structure with the new innovative technology normally finishes it in even lesser time. So 18 months time is because when the central government also intervenes and provides some funding for that, obviously we expect that this is completed at a faster pace. But in case ARSC is coming up with an old traditional technology, or somebody who says that, no, I don't want this TIG, they can make it in maybe 24 months time, 30th month time. But why I feel that this will be done earliest, because of the huge investment costs that somebody is making. Obviously, the private entity would want that it starts functioning as soon as possible. On Gopalji's observations, I would say that in terms of the central scheme being better, you can of course merge it along with the state schemes also, and we work in tandem, because you can take advantages of the Maharashtra scheme as well as load on to ours. And he probably mentioned about the monetizing aspect, but he forgot on the TIG. So TIG is also a very good sweetener along with the deal. And trunk bus infrastructure, as he told, will be provided. And in terms of legalities, I'm very happy to say that most of the state governments are taking the legal route. They are going to the cabinet. They are making a policy around this, because housing is a state subject. Therefore, in addition to our guideline, which is why we do not call it an act or this thing, the state governments will enact provisions or probably go to the cabinet and come out with a government order. And in terms of if there is this possibility, what Parveen said, that there is a piece of land which is owned by the government or has to be subsidized, yes, it is open for the state government to be able to provide land and get them made as ARSs within the EPC contract, or the state itself or the urban local body may enter into an agreement with a private party and run it. Like I belong to the UP cadre. I'm aware that JP Hotel in Agra has been made on government property, and JP pays an annualized rent to the government of UP. So these kind of arrangements we have made possible, which is why I'm saying that this ARSC policy is an ecosystem that we've tried to create. In fact, we are willing to hear you, learn from you, and perhaps even amend wherever necessary. We are so keen on its success. And even before the EOI has been released, half a dozen is there. And we are quite sure that once the EOI is realized and the private parties do understand, we are quite confident that we will hit the roof top and, we are ready to go. Thank you.
Thank you. Just one last point, Amrit, if you could clarify, because the rent is going to be fixed for a minimum period of 25 years by the local authority. I think that's the other area, because there is a capital investment which is factored in, and then therefore the rental in the IRR. But the fixation right is with the local authority, while probably, like you mentioned, this is the guidance and then the state will have to elaborate. The fact that it cannot be fixed in isolation without discussion with the participating developer company, so that the IRR which is planned can be achieved. I think that gap probably there will need to be worked on a little more then.
Okay. Very true.
Can I just Mukhopadhaya is trying to say, yes, sir, you're saying something.
I'll be just stating on one of my experience as a Chief Justice of Gujarat High Court.
Yes, sir.
You have heard of Sabarmati riverfront.
Okay.
Sabarmati riverfront was a full slum. The Chief Minister, Honorable Chief Minister, who is the Prime Minister for the present, Mr. Narendra Modi was the Chief Minister. In the evening, as a Chief Justice, I was surrounded by about 500 people. And they said that our slum, the government is going to throw us in the evening. So a PIL started, and we started an order of stay. Later on, with the discussion with the government and the court as a Chief Justice, it was decided that to utilize the JU norm, I'm talking of 2010, and temporarily to shift them to a place in a tent, followed by a place where by JU norm, the buildings will be constructed. They were constructed 60,000 per room, 1,000 rupees per month to be paid for 5 years. It was said that you can't sell it for within 5 years.
Certain period of time, yes, sir.
If you sell it within 10 years, you will have to give 75% of the margin of profit. If it is 20 years, 50% of the margin of profit. If it is at 25 years you sell it, it will be 25%. And after 25 years, no requirement. And inheritance. Actually, this was done under and from the government side. The Honorable Chief Minister, the then Chief Minister was very interested. The court was interested. 5,500 homes were constructed. 65,000 people were accommodated in between 2010 and 11. This is a history which is there in the past. I have seen myself.
Wonderful. So, in fact, it shows where the the complete balancing and approach of yours comes from. It continues right up to the National Company Law Tribunal, and we still saw the same outlook, making way for sustainable kind of interpretations. And of course, I'm sure this scheme seems to be inspired by the then Chief Minister, now Prime Minister. Also, the outlook remains the same, to try and bridge the gap and make housing available to the last person in the value chain at a very affordable cost. And now an improvisation on that which is being done is to give it to him on rental. Even if you can't afford 65,000, take it at 3,000, 4,000, or whatever you can afford as per the market rental going on. Taking the discussion forward, Parveen, you posed the question, and yeah,
just one on the trunk infrastructure, provision of trunk infrastructure, the responsibility that is put on the state government or the planning authority. Maybe I think you could come up with a solution that, okay, if I am the developer, if I am able to put up a trunk infrastructure as a developer, some kind of reimbursement be given towards that. I think that would also be of great help and assistance. It would expedite the process of the rental housing complex.
Sure, because there could be gaps in achieving it because of other issues or timeline issues. At least the developer can step in and meet the objective. Amrit, over to you. Just the last two.
Just reacting to Parveen this thing. So with regard to fixing of the rent, the good news is that I'm reading from clause by clause. It says initial affordable rent for the ARHC will be fixed by the entity as per local survey. So it is on the entity. So it will not be fixed as if it's cast in stone. It will be fixed by the entity. And the entity here is the private entity or the public entity, whoever is making it, on the basis of a local survey. Because as is obvious, if the rates aren't attractive, the migrants or the urban poor wouldn't come. And they can be revised from time to time. Why we did not go in for an every year revision is that it involves a large amount of bureaucracy, and this is not the kind of population which is very adept at all this. So 20-year increase over an aggregate period over 5 years, and it can be run until 25 years, and then it will be let out. So rents do not necessarily mean that it will be fixed by the urban local body as a one-way mechanism only. It will be on a local survey, but the entity will be fixing the rent and be revising it subsequently. And what Mr. Gopal was saying was the trunk infrastructure. I think we can make a provision where the state government is able to deal with it on project-to-project basis. It's actually, the show will be run at the local level. And my only issue with this would be that trunk infrastructure is generally provided on government-owned land. So some kind of an understanding would have to be arrived at. So, how can you make a road through your own money what the state is expected to provide? It's like traveling on a Delhi street.
In Maharashtra, we have what we call as an integrated township policy. So a developer who owns around 250 to 500 or maybe more acres of land, he is able to, the responsibilities on him. So if some kind of reimbursement is given to him for, meeting the cost of the trunk infrastructure, that would be of great help and assistance.
It's a very good input.
Since these have to be connected with the other government services, all the trunk infra, it will be a difficult task for the developer to do that. I think the responsibility has to lie with the government, but at the same time, yes, it needs to be pushed to expedite so as to match with the pace of construction. Like in North, especially
this is to be pushed through.
The buildings do come up, but the trunk infra around it are not ready. So yes, that kind of matching has to be done.
Correct. So in some states which have a township policy, possibly the affordable rental housing complex may land up within and right in the heart of the township already given out to a developer. So therefore, in those cases, as an exception or based on a state policy. But over to you, Amritji, you mentioning something.
I think taking a cue from what Mr. Gopal is saying, I think we will make some provision that the trunk infrastructure has to be in tandem with the project period of the affordable ARHC complex. So there is some pressure on the executing agency to do it on time, because I quite realize that there may be a contradiction that the complex is ready and the road isn't good enough to, for people to shift in and ply on that. So I think that this is a very good input, and we'll try and address it either through the township policy, or we'll make a provision that the trunk infrastructure has to be in tandem with the ARHC complex so that they finish around the same time, if not on the same day.
Thank you.
Thank you.
In fact, just taking the cue from addressing the issues that the migrant laborers and the people who are at the lowest chain of the economic scenario. Moving on to the developer side, if we look at the three key speakers that we have from the developer side, they are seeing a completely different scenario. There are issues which have arisen out of COVID, which are issues of delay in execution of their contract. There are delays on the planned construction schedule, and it has arisen because of many number of scenarios, including the labor disruptions, the critical supply chain disruptions, or a delay or inability to obtain required permits and unforeseen events which are impacting the availability of financing, each of which is beyond the control of the parties. So, what are the kind of imminent legal and regulatory challenges for the real estate sector as a result of the COVID-19 pandemic that you are all seeing? And I would want to start with you, Anjana, and then go on to Parveen and Gopalji as well.
Sure, but sorry if I may just add on to what we were talking on the affordable rent housing. Just one small point.
Sure.
As it normally happens with most of the schemes, the objectives and we all plan out with very, very good intention. But sometimes we're not able to achieve the intention with which we started out. Like it happens in EWS also. You will see most of the EWS being purchased by well-to-do families and used for their purposes. So I hope something is being done to make sure that that gap is not there and it reaches the right target audience and right kind of people. Like I heard the concept of aggregators is there. I hope there's no black marketing, which is eventually happen. And while there be maybe a capping of 2,000, 3,000 per for the rental, but something else is going in somebody's pocket. Sorry for being a little negative there,
No,
but
no,
I
not
think
at
this
not
is
at all.
good
Just,
to be
balance
aware of.
just attempting to answer that in a very quick, and then I'll leave it to Amrit to add on to it. This scheme envisages a tie-up between the employers of the workmen or the low-income group, and apart from that, for the others, by identifying them in the other classes that were mentioned, students and standalone people. But largely, it tries to identify these segments in groups and tie-ups, which is also going to be beneficial for the developers, because they would prefer to realize rent from an employer in a very organized manner by way of deductions from salary and handed over, rather than going after retail tenants for a 3,000 to 5,000 recovery, which is likely to be a nightmare. So possibly some of these safeguards and maybe more that is inbuilt, which Amritji can add, is there to ensure that there's no black marketing or misuse of creation of assets and using it for ulterior purposes. Amritji, over to you.
It's a good question. We did discuss on these issues. There could be a couple of responses to this. Number one is that this scheme is more like an ecosystem which inbuilt incentives. We are really not investing in it in a big way if it is not being made by new technology. The government of India actually is not giving out money, but is giving incentive in terms of policies. Therefore, a private entity which actually makes would have to look into the profit component. But having said that, there is a class of people we are trying to address. But if it is being misused or sold, we have to be very cautious regarding two things: that we are accrediting it in any way by independent accreditors. Apart from the fact, suppose there is an industrial unit where people come from a particular industry, and if somebody from a very high elite segment wants to usurp the facility and wants to go and stay with them, I don't really think that kind of a situation is happening unless all of it was planned with a connivance and a conspiracy itself, which in any case in today's democracy is very easy to detect. That you make a 30-room house with an intent of showing that we will be accommodating urban workers of, say, jewelry industry in Surat, and you actually give it out on rent to students, or maybe professionals working in the computer industry. Immediately we'll get a complaint, and the state government would be able to do it. See, this is something that comes from PMAY, that an element of trust has to be built in within the people, despite the constraints of our systems and the workspace that we build in. See, in PMAY, we just did one thing, that one Aadhaar number is enough for us to detect if the guy has taken houses in 2 places, or what his earning is, or those kind of things can now be detected. But yes, I take it with a pinch of salt, and we have to be cautious as a society and as a system that they are not tweaked to again benefit the people who it is not intended for, and we will be up on it. Thank you.
And similar to ERERA, I think the whole aspect of having a complete transparency by listing on the website of all the projects and giving ample opportunity to anybody who would want to pick and verify on a sampling basis, or maybe more. I think the transparency element built in may help in anybody's initiative. I mean, we can't stop somebody from imagining ways of circumventing, but possibly some transparency would go in a long way in addressing some of these issues.
Yeah, in our website, we will have arrangements where rooms will be displayed, where camera projections will be there. We got confident that this should work, but yes, I'll of course admit that there are always people in our system who we have detected through our CLAP system in CLSS, where some people have taken a house under some other vertical at one point of time, did not disclose, use the same different Aadhaar with the same name. So it's a one-upmanship going on with such elements, and we should be able to address this as we go along.
Shweta, over to you.
Yeah. I'm waiting for Anjana to respond on her.
Thank you so much, Mr. Amrit, for sharing wonderful policy with us, and it's very, very positive, very, very encouraging, of course. Coming back to Justice Mukhopadhaya, thank you so much, sir. It was a wonderful insight into all that you've done. We've all been following, of course, whatever judgments you've been passing. Sometimes we've been just sitting in the courtrooms to see how you conduct your proceedings, and it's been a very, very positive and encouraging,
very unique
thing.
Today, actually, I have a question. With regard to this EWS scheme, etc., I am telling you. Now, this unorganized labor, when we talk of a society which is developing, where a township is developing or some flats are coming out, and EWS is there, the laborers who are working over there, the migrants who are working over there, will never purchase a flat there, because they will be migrating from there to another place the moment the work is complete. So those people will never come. But who will come? The maid servants, the servants, and others who are like Thelawala, etc., who are doing business in the area. They may come and purchase these flats. No, that means those who are temporarily settled over there, but those migrant laborers, they will never go for it. Because from one project is complete, they will go to the other project. So they will never purchase. So one thing can be done, that during the completion period, they can be allowed to complete the EWS first. Accommodate the laborers there to work. After the work is completed, complete the EWS, giving a finishing touch, and then give it to a third party. I think some sort of formula is to be found out by the government in the manner.
Correct. The misuse has to be, of course, sidestepped always. Very rightly said that.
On to sir's observations. Sir, I just like to tell you, you may already be knowing, sir, where in the construction activities going on, that is funded by a construction cess, and the builders are legally obliged to be providing accommodation during the period of construction, from where, as you rightly said, they will migrate to site B, site C, wherever the construction is going on. But such laborers who are tied to a project, we are also sprucing that up in terms of facilities being offered at the construction site. But that is being governed by the CPWD in a very comprehensive manner, and they have come out with revised guidelines, and they are also working to suit the requirements now, wherein the builders through the state governments are obliged to provide basic facilities and some crèche and education facilities, so on and so forth, during the construction period. They are not necessarily the clients for ARHCs, but if they choose to be so, there is no bar also.
Thank you.
And yeah, Anjana, over to you. You're mentioning.
Yeah, so we were talking about the challenges to the real estate industry in the COVID times. I think, like any other sector, or rather more than other sectors, India's residential real estate business will be shaken from its foundations, honestly, with the impact so severe. Developers will need to, stare through various challenges all at once: low demand, deferred demands, liquidity drying up, changing of customer preferences. So all these challenges are going to be there. Sales and rentals are already majorly impacted. While A-listers will stay through. I'm sorry for using the word A-listers, but yes, there are some highly compliant, well-to-do developers. They will sail through. There'll be some B and C category companies which will face the heat. Their sales have gone down, likely to remain down, as the demand for ready to move in has probably gone up. It has risen, and decline for under construction properties is there. Brand value would be very important, as we all know, and confidence of the customers and developers who've not been able to deliver so well or timely, their confidence in these kind of companies will definitely waver. And once that happens, there will be defaults by these companies, and NBFCs will also face the heat as last defaults. The projects will turn unviable. So all these challenges are going to be there for sure. And this will also stress the financial institutions. So I guess, but a contrarian view could also be that now we are back to basics. So everybody understands the need for a house, which nobody understood so much before than now. And there'll be fence sitters who would finally commit to buying better homes. Now, in fact, in an urban middle class, people are looking at houses where every individual in the house has a room to him or her. Everybody needs a workstation, everybody needs a online classes, so bigger houses could also be required by them. So I guess these are the challenges, of course, which companies will have to sail through. And on legal front, with the ordinance coming and moratorium given, they probably what is going to happen is that people will probably look at trying to settle disputes with the developers. I'm talking about the home buyers right now. So maybe they will look at settling the disputes with the developers, and developers would also probably extend an olive branch. That's at least the positive view that I'm taking, that so that some sort of deadlock is broken, and a lot of time is not wasted in courts or in other forums, where sometimes the resolution is never ending. It doesn't come so easy, because developers also take the proceedings till the Supreme Court, which is not very happy situation for the buyers. Hope mediation and arbitrations are there to resolve these matters. The extended time frame of 1 year to complete the project and avoid defaults under IBC now, and compliance timeline under RERA, which has got extended. Hope this will also help the companies to sail through, complete their projects. After this also, if they're not able to complete, then of course we have the NCLAT to take them to task, of course. And genuinely interested developers can use innovative techniques to develop projects and utilize the ordinance to the maximum. So the ordinance, yes, sir. Sorry, sir. Just Mukhopadhaya wants to say something.
You see, I think something more is to be done.
Yes, sir.
For example, the law has been amended that 100 allottees or 10%. But so far as other financial creditors are concerned, or operational creditors are concerned, 1 lakh is for them to trigger. So one operational creditor or one financial creditor for 1 lakh rupees will trigger, and hundreds of allottees will suffer.
1 crore. In fact, Shweta had flagged this question.
Yes.
Why don't you elaborate on it, Shweta?
Exactly. A question for you.
Therefore, I think there should be minimum, it should be 1 crore or something like that.
So 1 crore is done now. They have now
increased
the pecuniary jurisdiction to 1 crore, but still I have a question for you on this.
So March 24th amendment is there.
Yes. They have
increased the thing to 1 crore.
We have for operational creditor and others,
Yes.
Those who have defaulted after 24th March.
Yes.
Yeah.
But there is no, it is not meant for those who have defaulted prior to
There too. Yes. Yes, it's prior to the amendment. But still, I mean, if you look at the financial creditors or the operational creditors, they may approach the NCLT with a claim of 1 crore or more. However, when it comes to the home buyer who would have bought a property worth more than 5 crores, he is precluded from approaching the NCLT, even though he has been held to be a financial creditor within the definition of Section 58F of the Code, as per the Pioneer judgment. So how can this amendment be harmonized with the intent and purpose of the Act going forward? And how are the home buyers expected to have the data relating to the other 99 other home buyers? So I think these are certain questions which have been left vague, and I thought I would request sir to give his comments on exactly how will this provision look like, and how are we going to create a right balance. And also, if the cases are to be taken up, not to be taken up individually, then the defaulters who are also not paying the AMIs on time, they are also going to get the benefit out of this entire provision. So how do we create a right balance, sir? Is this amendment really going to serve the purpose that it was meant to be?
Actually, amendment will not serve. It is case to case. The judges will have to sort out, the members of the NCLT and NCLAT to sort out. They will have to intimate the financial creditor or the operational creditor that will you take the flat in lieu of your money. If they agree that they will go for the secured, as a secured creditor for a flat, then they may be allowed to trigger. Because till they become, because allotee first is the theory for, according to me. Allotee first, rest latter. Secured creditor like a bank will be latter, but unsecured creditor like the allottees will be the first. So if those who are in the second category, if they want to join the first one, that all right, in place of 10 crore or 1 crore, I need 2 flat, I can understand they should be allowed. Otherwise, they should be also made like this, that jointly you should be equivalent to either like the allottees. Your jointly, your investment should be like 100% of the allottees or 10% of the allottees. That means they will have to be equated. So their investment will have to be shown is equal to the investment of 100% of the allottees or 10% of the allottees. Only in that case, they can be equated. Otherwise, there will be a discrimination. It will be clearly violative of Article 14 of Constitution of India between two types of financial creditors.
Correct.
So the financial creditors eligibility to trigger at 1 crore is actually needs to be revised and therefore taken back to at par with what is available for the allottees. 10% and whatever else figures are provided there.
The amount invested must be 10% of the amount invested by the allottees.
Right.
Or 100% if they have invested, it must be like that. Then only they can be allowed, not 1 crore.
Right. Absolutely.
So in the interest of time, Shweta, can we also have more inputs from Parveen and Gopalji and
Anjana? In fact, that is what I
legal...
wanted to understand. Anjana made a very interesting point with respect to amicable resolution between the developers and the buyers. Now, with this kind of an amendment where there is a requirement for at least 100 number of buyers or 10% of the numbers to come to the NCLT, do you think that the chances of settlement has gone down for them? Because when it was only one allottee going to the court and or the tribunal with their case, the chances of settlement was higher as compared to now you settling with 100 people. So do you think that this number of settlements are going to go down with this kind
I don't think so, Shweta, for the reason that it is just not the IBC. So see, IBC was once the home buyers became, were defined under as financial creditors. Of course, there was a big scare in the real estate industry from the developer's point of view. And I will share that perspective only. But thankfully, the working of the code is being monitored by government, and expert committees have been set up on this behalf too, so that there are amendments in short periods of time. But it's just not the IBC. There is RERA also. There are consumer courts also. So I don't think so. This will give a push to settlements. Settlements, in any case, from my personal experience, is always the best way forward. Otherwise, litigation is always prolonged, and corporate debts of a developer company, through the NCLT, etc., according to me, is not a solution. At least not where the company is genuinely interested. Yeah, projects are delayed, undoubtedly. But thanks to the judgment in this reverse corporate insolvency resolution perspective, we have a harmonious balance between the two. Because at the end of the day, NCLT can't be used as a forum to just recover your money.
Yeah, I'm twitched.
And as Sir rightly pointed out, allottees first, fair enough. Allottees first, number one. Then homes to allotee is the priority and not the money back to the allotee.
Correct.
So if this is used as a thumb rule, I'm sure we can move towards, resolving these issues.
Sure. Now coming to you, Parveen, there are certain steps which have been taken by the government with respect to increase in pecuniary jurisdiction, or say the suspension of initiation of CIRP. Do you think that these are adequate measures of safeguard for the real estate industry, or there is something more that is required to be done by the government, in order to enable the real estate industry stand up on its 2 feet?
Sure. Thank you. And I think, Justice Mukhopadhaya, the order that you have passed, and, Shweta's been a large part of it, is a really welcome move, because there was, like what Anjana said, a huge scare when a single home buyer, and yes, I say that the real estate sector has been plagued with a lot of mistrust, and therefore there was a RERA and an IBC requirement where home buyers were included. But with that said, it is not all developers that fall into that. And the objective of any legislation cannot be to completely kill a sector. So that bit of harmonization where people and companies and developers that are level playing, transparent, or wanting to be compliant should not be taken for a complete extortionist ride because you have an IBC case against you. Because what really happens is, when there is a matter which is filed, any standard PSU banking document specifies it as an event of default, where any petition is filed, not even admitted, and that triggers an entire recall of a loan. So there were huge ramifications to the entire, IBC issue, and which is now, been resolved through amendments, as well as, the judgments that, are being passed, including by you, sir. So yes, that is a welcome move. Shweta also touching slightly upon the moratoriums and the extensions that have been granted, by RERA. While that is one portion which is done, there's a lot of consequential work that needs to be done. So if I give you an example, in the north, the sub-registrar currently is not functioning. There is a technical upgradation, and there is a couple of months halt for that. But you've spent money, you've called migrant workers back so that you can complete the project within the extended timeline. But you cannot now cross the 10% collection without registering the agreement. But the registrar is not functioning for that. So I think some kind of brainstorming where what are the other consequential relaxations that need to come in. So say, for example, RERA relaxing the 10% requirement, at least increasing it, saying, okay, you can reach a 20-25%, given the COVID scenario. There needs to be a kind of a representation going for the other parallel relaxations that are required. The stamp duty reduction move is a welcome move in Maharashtra. But then you have states like Karnataka, where the ready reckoner rates in certain places are much higher than the market value at which a project is selling. And there's a huge outflow of stamp duty in that state, which impacts the entire saleability of the project. So if the whole economy, not just in India, globally has gone into a reset, then let's use this as an opportunity to reset a lot of things which will really help the sector in a large, meaningful way in the long run.
Sure.
That's right. Just on the stamp duty issue, before moving on, I recall some discussions going on deferred collection of stamp duty in terms of, especially when things come to a complete standstill and the whole large chunk of transactions have to be implemented in one go. The viability of achieving these closures of these individual transactions. So therefore, giving a window of deferred collection, let's see what direction it takes in times to come. Back to you, Shweta. I think Gopalji, some thoughts from your end on.
Yeah.
You are muted. You need to unmute yourself.
Sorry. Anjana, I think, has very succinctly put in, the real estate industry is virtually at the crossroads, at all levels, be it regulatory, be it funding, be it construction, be it delivery of homes, be it satisfaction of the customers, and so on and so forth. So, the industry will definitely look to the government, to seek and also get all kinds of assistance. It just, I would say that this kind of assistance would be required for the next at least 1.5 to 2 years, and would, help bring in some good developers on the in the market. It would help also bring in good foreign direct investment. It would help, growth of the employment, and so on and so forth. Ultimately, this would be one of the largest employers in the country, and government will have to really step in some form or the other to help alleviate the issues that the real estate industry. When I say real estate industry, there are several stakeholders, again, as I say, right from the landowners to the developers to the banks and financial institutions, purchasers, everyone down there, and including the government, because the government really also gets a lot of money from the developers by way of development charges, the premiums that they charge, by way of stamp duty, by way of GST. So I think we would be looking definitely to the government to get, and definitely Amrit will have to throw some light on it.
In fact, in the interest of time, before we start going for the final comments, Shweta had one interesting question which she had parked for Honorable Justice Mukhopadhaya. I would request her to take that up on force majeure and issues. And then we can go to do a round of closing remarks and request Amrit also at that time to cover some of these aspects that Gopalji has raised just now. Shweta, over to you, and then we'll initiate the last round.
So we are in a situation of force majeure, and so this the force majeure is arising out of the COVID-19. How will it be treated by the tribunals, which does not necessarily fall within the realm of a pre-existing dispute and is more a contractual interpretation? So how is it going to be interpreted by the tribunal, sir? I thought I'll pose this question to you to understand a little bit.
I think this is the reason I have given the reference of the case of Nabin Reheja versus Jan others.
Yes.
If you look into that, is Company Appeal 80 Insolvency number 864 of 2019. The judgment was delivered again on 22nd January 2020. Measures we have taken into consideration there.
So,
and for example, when the matter, if the flat is complete, if it is complete for all purpose, the completion is one, and giving possession is another thing. Registration is a third part. So my duty is to complete it.
Right.
My duty is to apply for fire extinguisher, fire report, etc. My duty is to apply for the purpose of giving possession or a certificate. If I complete my duty, there is no default on my part. If the party can show that there is no default in his part, but it is because of the part of the government or semi-government or any other organization, then in that case, there cannot be initiation of insolvency process. The one person who has initiated or 10% who has initiated, one can show that I have completed their part.
Right.
And that part completion, even the permission can be granted by the development authority.
Right.
I have applied to them. Now, for example, water supply.
Yes.
Water supply can be by tanker also.
Right.
But water department will supply is not in my hand.
Right.
So those are the things which have been discussed in Naveen Raheja's case.
Sure.
That those are the cases, the case should not be admitted.
At all.
Yes.
Because there is no default on the part of the corporate debtor.
Right.
Fault is not that you said that you will be completing on within 3 hours, 3 years. I have completed within 3 years. Now electricity line I have applied for, not given. Water connection I have applied for, not given. Half completion I have applied for, not granted. The lease has not been completed. For example, Noida, they have given me time to pay the lease amount in doublets, but they are not giving the certificate.
Right.
Which is not in their hand. No initiation in absence of a default. Default does not mean the time. Default means that a default by me, which I was to complete, not that others were supposed to complete.
Right.
You know,
it also includes the COVID situation, sir. The COVID-19 situation has also created a unique kind of a force majeure where we don't have the labor supply. So we are not in a position. I mean, when I'm talking about we, I'm talking about developers. So developers are not able to complete the project on time. So that is a unique force majeure, which is also not within our control. But in that case,
that is, everything has been taken care in this Naveen Raheja's case, and that case was rejected
in Supreme Court.
We have taken into consideration that how much, what we have done. While dismissing the case, we granted them 2.5 years more time to complete. To extend the period of default that within 2.5 years, nobody can again trigger.
Correct.
You understand?
Correct.
The moment the tribunal, it's actually the court will have to, or tribunal will have to play a role. That giving time in such a case that there is no default, I'm rejecting, but I'm also giving you 2.5 year time to complete. So that a financial creditor cannot tomorrow file a case because there is a bar by the court's order extending the period of 2.5 years. These are the things actually the lawyers will have to develop.
That's true.
Members and the judges will have to apply their mind. Based on the situation, the things is to be moved. I'm telling you, the problem will start with regard to NBFC companies, which are going to be triggered in future. I'm giving advance notice to you who are the operational creditor and who are the financial creditor. People will be in dark to find out about the non-banking financial institutions, that who are they. So those things will come. It will take another 10 years for insolvency to develop. Let it develop. I was a part of it. I am happy that I have enjoyed the law. I am happy that still you are asking me to apply my mind. And I'm telling you, apply your mind. Let the judges understand that these institutions should suffer. Industries in India should suffer. Should not suffer. They should survive. The law is for survival. Law is not for the purpose of liquidation. That should be the essence of the law. How to survive, how to give a medicine, and how to give them, more time. This is a trick a judge with the judgeship mind cannot do.
Absolutely.
You have to forget that I am a judge.
Yes.
I forget that I was a judge for more than 20 years when I was the chairperson of the NCLAT. As a judge, these things cannot be done.
Correct.
This is to be done when I will be sitting there. I'll have to think if I am the infrastructure company. I'll have to think that if I am the promoter, I'll have to think if I am the corporate or say financial. So my position, what would have been the thing, this is and how to solve the problem. So it is, resolution is nothing, but it is a solution, which is the resolution.
Absolutely. Thank you so much, sir, for your words.
Just one small query with regard to this Naveen Raheja judgment. It's a very positive judgment that you've given. Can the logic and the ratio from this judgment also be taken to the consumer courts and RERA? Because it's not just the insolvency part. Post measure applies there also. So how is it that in most of the judgments that we are seeing, and what is being noticed is that the courts are passing orders whereby even if the deficiency is not on part of the developer, but on part of the government granting some approval or some trunk infrastructure not getting complete, we're coming back to the same issue of trunk infrastructure. And the courts have said that the project is not complete, so there is deficiency in service on behalf of the part of the developer. So this logic has to be applied there also.
This is not logic, this is a ground.
Correct.
Logic cannot be accepted, it may not be accepted, but a ground settle is to be accepted.
Right.
It's a settled principle. Now, once a principle is settled, that principle is to be followed by all the authorities of the state. NC will have to follow, NCLT will have to follow. The other institutions below it, they will have to also follow because there is a principle laid down under the law.
Correct.
Till it is reversed by the Honorable Supreme Court or some other finding is given by the Honorable Supreme Court, which is final.
Thank you so much, sir. Very correctly said. In fact, this whole process of these new situations that we're facing from time to time, we have fortunately had some very good foundations on interpretation of some key provisions of the insolvency code, and more significantly the nature of outlook that NCLT ought to have as a balancing act to balance the interest of all stakeholders. Yes, sir, please.
Find one thing.
Yes, sir.
The law do not provide extension of time beyond 270 days. So NCLAT find out, all right, extension is not permitted, but exclusion can be given.
Yes, that's right. That was a very important judgment again. Yeah.
These are the ways and means which have to find out. If extension cannot be given,
exclusion is not
exclusion can be given. There's no bar under the law. Sure. So it is like a chess one will have to play, that where I have to took the pawn to get the queen of the other side.
Correct, sir. In fact, as you said that as lawyers, as stakeholders, we'll need to continuously keep working on these to navigate through more and more similar issues as we face forward, especially the force majeure issues that Shweta was referring about, how it would be handled going forward as and when it reaches the center point before NCLTs across the country. In the interest of time, may I now request for closing remarks from each of the panelists. We could start with maybe Amrit. Ji, can you request you for some closing comments? You've heard the entire discussion all through. A lot of expectations, a lot of takeaways for everybody else in the panel, possibly some takeaways for you in terms of what we could look forward to going forward. Closing remarks from you, sir.
Absolutely. Most excited to be a part of the discussion today. And I'm also very emboldened and very happy that I think that the knowledge on ARHCs and how it's going to be functioning is perhaps more than what I really expected, which means that we are on track and we are presently on a very aggressive IEC mode because, the people take time to understand the nuances. So happy to interact with the informed panel, audience, everything. And as we go ahead, I'm sure that this will add to greater understanding of this subject matter. And also probably when you talk to many people in the industry and as your clients, there would be greater appreciation and off-take as well. I would be like to personally thank Justice Mukhopadhaya also for his very sustained, deep, passionate analysis of the sector. And it's absolutely a joy to see and learn that people are so learned, informed, and interested, despite being even in the post-retirement stage. So it's really been very, very beneficial for me personally, and also from the other panelists who did comment and have been asking questions. So as we grow along in the ARHC model and PMAY, we would certainly like to take these inputs and do whatever best we can. Thank you very much, Manoj, for this opportunity. Thank you.
Welcome. Thank you so much for joining us. Parveen, some last comments from you, thoughts?
Yes. Firstly, I want to thank Justice Mukhopadhaya for having a very forward-looking judgment, providing a very balanced view to the sector. Much appreciated. I think there will be a lot of impact because Section 29A of the IBC probably needs an amendment or harmonization with how Section 8 of the RERA would operate. That's yet to be seen. Thank you, Amrit, for a very forthcoming discussion. Appreciate that we could talk this openly and have, something which is in the interest of what we're really trying to do together. Shweta and, Dr. Manoj, thank you for this opportunity. And I think it's made such a wonderful combination of a panel. So kudos to how you have done it together. My co-panelists, Anjali and Gopal, for insightful comments from your perspectives. I'd say the sector is here to stay. It is always because we don't have the concept of social security as exists in other developed markets. Most of us spend our lifetime earnings into buying that one home, and therefore there is a lot of probable angst as well as the transparency which is required in this sector, which does need to be addressed. And therefore the importance to the sector, if we continue to work in the manner that we are currently working, will definitely help the economy.
Thank you so much, Parveen. Your words are very encouraging, and it will keep motivating us to curate more such discussions which are very purposeful and impactful in the immediate future in terms of what each of us are doing in our respective domains. Gopalji, may I request you for your last remarks, please?
Thank you, Justice Mukhopadhaya, for the insightful, I will say, view of how the insolvency or the reverse insolvency process must be carried out. And the whole purpose is that the industry must remain alive, not to kill it. It would really help all the stakeholders to move forward. Maybe in some other matters also, for some other industry, in some other manner, it might be helpful. We hope that this judgment comes to the rescue of some other set of people also. And thank you, Amritji. I think this is a very encouraging mission that you are spearheading. Definitely, developers would be, keen to consider the proposition and also expect a lot from you just to make it a success. All the best to you. Thank you to Shweta and Manojji and my co-panelists Parveen and Anjana. Thank you very much.
Thank you so much, Gopalji. You're always so clear and lucid with your thoughts. Anjana, over to you for some last thoughts.
Yeah, I'll keep it very
and
short.
you've had some very clear views on what we should be taking guard against. I think that was a great input. Please, last thoughts from you.
No, thank you, Shweta and Dr. Manoj Kumar, for giving us this opportunity to be in august company of Justice Mukhopadhaya and Amritji. It's been a great afternoon. Justice Mukhopadhaya, sir, it's been so reassuring to hear you, not only through the judgments, but also that, yes, there is somebody who's looking at every quarter, somebody who's guarding everybody. So at the end of the day, I think Madhya Marg is the best mark to follow. And that's what we are all trying to do. It's reassuring to the developers also, because if they survive, they will be able to provide housing, which is the ultimate aim. And this industry has to survive, it has to do well. It's one of the biggest employers in the nation. And we need support from people like you, of course. Yeah.
Thank
And
you so
thank
much.
you, Amritji. This was very educative. And I wish you all the best. We hope we are really able to do something well for the migrant laborers and all those people who are in need of housing. I think in some way or the other, legal community and real estate, if both combined, we're doing great service to the nation. And we should do it with the best of our intentions.
Thank you so much, Anjana. In fact, we all have to, collect our strengths together and ensure that, schemes like the Affordable Rental Housing Complex Scheme, which are actually meant to reach our folks at the lowest level of the value chain, they get benefited, and the scheme reaches a impactful conclusion sooner than later. Shweta, before I request for our last words from Sir, some of your thoughts, last words from you.
So I want to only thank Justice Mukhopadhaya for his very eloquent expression of the thoughts, the ideas, the basis behind passing of those judgments, both in the case of Winter Hills as well as in the case of Naveen Raheja. And I think it was very insightful to have this discussion today. Thank you, Amritji, for your views. It was great to understand the entire the scheme that you have come up with and the kind of implication it is going to have. It is really going to have a wide-reaching impact, and I see there to be a huge benefit that it is ultimately going to give to the large section of our society. So I think it was an interesting discussion with both you two panelists, along with the great insights from Gopalji, from Parveen, and from Anjana. Thank you for sharing your thoughts with us. And I understand that one size fits all is not the right way of thinking, and therefore we will have to come up with unique solutions when we approach the tribunal and use this platform for discussions like these in future as well, and we are able to have more meaningful discussions. So thank you so much for being there. And just one word for the people who are listening, that not all the developers are cheaters, and therefore trust them. And I think we are coming up with great projects, and we have some very credible names in this industry, and we really want this industry to thrive. And therefore the objective of this discussion was to ensure that we are able to provide for the right platform for people to pose their questions, understand the implications of the kind of situation that we are in, and then appreciate the kind of effort that has gone into it to making the real estate industry the way it is now. So, over to you.
Thank you so much, Shweta. In fact, Shweta's passion on the insolvency side has been a great driver for some of our milestones, including the one judgment we discussed today. And of course, very recently, navigating a proceedings against India's largest utility company, BSES, and getting a CIRP proceedings initiated against BSES, purely because there was a misuse of the forum. And therefore, again, here NCLT stood up and said that your size doesn't matter. You need to work in a manner that you carry everyone along with you. You may be a very big utility company, but then every stakeholder in the value chain matters, and therefore they granted a CIRP proceedings. So Shweta's passion shows, and as you can see right here on the screen, and we're all familiar with that. Thank you so much, Shweta, for bringing us this up till here. Sir, just may I now request Justice Mukhopadhaya to give us some pearls of wisdom we should be carrying with us to navigate through what is yet to come going forward before we close the discussions today.
Yet to come is the problem. And what you will have to do is to sort out and solve the problem. Every day, you will have to make out a case in a manner where there is a struggle. Wherever you will be getting an obstacle, find out a way which is a bypass through which you can get rid of it. So my suggestion to the bodies who are before the NCLAT, those who are drafting the rules, those who are looking into the matter, look into the real problem. The problem till the people know the problem of the industries and the business. In one hand, we'll be talking of giving benefit to the industries and other countries should come. We should not allow those who are already existing to die. How to get them survive should be the first theory, and ensure that before admission of a case, if it can be sorted out. Second, if it is admitted, then before constitution of the committee of cater, let it be sorted out. Even if a committee of caters is constituted, let it be sorted out under 12A. So let the person, the promoter get it back first. 3 stage, they should be given. Only on failure, it should be given. So far as Pradhan Mantri Yojana is concerned, I will have a suggestion that wherever the Yojana will be there, it will be successful if you can make arrangement of simultaneous communication from the place. That means arrange some bus service which should be there, or a train service, or any other service without which none of the scheme will come out successful. You may have a flat, you may have everything. If the road is not there, if communication places, the transportation is not there, so make it a part of the scheme that should be also there in the Pradhan Mantri, what you say, Yojana with regard to the house. Then Sarak Yojana should be added to it, and JU norm or through any other norm, let there be communication, transportation, which can be allowed to the poor people who will be getting it, who will going to the township for the purpose of their livelihood. That's all. That is my request. If you can club all these three together, I think everything will be successful in India. There is no other way. But success is our aim, and that will be getting. COVID or no COVID, COVID has shown us only the way. COVID shows that we'll have to now respect the unorganized worker. COVID shows that those who are supposed to be ignored will have to respect them. So this is a new thing which has come to the notice. I think today bankers are understanding, industries are understanding, business people are understanding that these small people are actually our leg on whom we are standing. If they become weak, we can't stand. And for that, we'll have to strengthen our bottom portion, that is those who are in the downtrodden, the unorganized labor sector. That's all. Thank you.
Thank you so much, sir. In fact, for putting it so wonderfully, that the lower segment of the value chain is the legs on which we stand. More so in the urban areas where the entire machinery of development and livelihood works around this segment very strongly. Thank you so much for joining the panel today. May I take this opportunity to thank each person here, each one of you, Honorable Justice Mukhopadhaya, Shri Amrit Abhijat ji, for joining us today. In fact, but for you, trying to curate a discussion on seemingly unconnected or disconnected or different issues like affordable housing and IBC, and right in the middle of the whole difficult scenario today, the real estate sector, which is supposed to be navigating through these difficulties and also assisting the government in achieving this major milestones. So this discussion today has been possible only because of your availability and joining us today and giving us your valuable thoughts. Thank you for that. Parveen, Gopal ji and Anjana, thank you so much for taking out time and spending time to evaluate. Of course, these issues are very key to you as a sector, the affordable housing scheme itself, the IBC itself, but spending our time, applying your thoughts, brainstorming with us in the bridging sessions on what could be the possible bottlenecks that we need to overcome in the immediate future, and how we could discuss to find a way around that. And of course, thank you, Shweta, for co-hosting this discussion today. Thanks a lot, and we can now close the discussions today.
Thank you. Thank you.